Welcome to the Politics and Media programme with me, John Rees. MPs have warned the government that they shouldn't ignore the threat of far-right terrorism. The warning came in a report about radicalisation by the Home Affairs Select Committee released last week. MPs also said that the internet was one of the main avenues of radicalisation and that internet service providers needed to regulate websites more strictly. Well, before I introduce this week's guests, let's take a more detailed look at the MP's report and the issues surrounding it.
In 2011, Anders Breivik became the instantly recognisable face of far-right extremism. He killed 77 people in Norway after setting off a bomb outside the government headquarters in Oslo and then going on a shooting rampage at a Labour Party youth camp on Utøya Island. He's now on trial for the attacks, for which he's shown no remorse over, and which he has described as a strike against traitors who he said are embracing immigration to promote an Islamic colonisation of Norway. Now a new report on radicalisation by British MPs has warned the government of the dangers of far-right extremism and the internet. The report described the internet as one of the few unregulated spaces where radicalisation is able to take place, and claims it's played a greater role in promoting violence than prisons, universities or places of worship. MPs also urged internet providers to do more to remove violent extremist material. However, the report concluded that violent Islamist radicalisation appeared to be declining and that the threat of the far right wasn't being adequately addressed. A view was expressed by some of those giving evidence to us that the revised Prevent strategy only pays lip service to the threat from extreme far-right terrorism. We accept that Prevent resources should be allocated proportionately to the terrorist threat. However, we received persuasive evidence about the potential threat from extreme far-right terrorism. The ease of travel and communications between countries in Europe and the growth of far-right organisations suggest that the current lack of firm evidence should not be a reason for neglecting this area of risk. In response, a Home Office spokesman said, "Our new Prevent strategy challenges extremist ideology, helps protect institutions from extremists, and tackles the radicalisation of vulnerable people. Above all, it tackles the threat from homegrown terrorism on and offline. We are working closely with the police and internet service providers to take internet hate off the web. We are pleased the Home Office Committee and the witnesses who contributed to its report broadly support the outcome of the Prevent review and the revised strategy."
Well, with me to discuss this is Nick Pickles, who's the director of Big Brother Watch, an organisation which was set up to challenge policies which it sees as threatening our privacy, freedoms and civil liberties, and to expose the true scale of the surveillance state. Welcome to the programme. We also have Jack Holland, who's a lecturer at Surrey University in International Relations and who's extensively written about American and British foreign policy and the war on terror. And joining us on the phone, we have Liberal Democrat MP Julian Huppert, who's a member of the Home Affairs Select Committee. Welcome. Julian, it's your report. So, first of all, why did the MPs feel it necessary to underline the question of far-right terrorism in this?
There's been various pieces of work about violent extremism that's been conducted both here and, for example, in the US, where the Homeland Security Committee are having a look at some. And they tend to automatically assume that all violent extremism is Islamist violent extremism. And that simply isn't the case. And we wanted to take a much more balanced look and say, what we're concerned about is violent extremism, whatever the cause. And actually what we find out is that Islamist extremism is on the decline, whereas, in fact, we see worrying threats, as we say in the report, from the right wing.
OK. Jack, now this is a shift that began under the last Labour government. The Prevent strategy was in trouble. One of the sort of last kind of manoeuvres to make it sort of look a bit better was to broaden its remit. Do you think this is a sensible way of dealing with it? Does it deal with some of the problems that Prevent had?
I think you're probably right that before we get to some of the criticisms of the new strategy and the revisions, it's right that actually there has been some progress on some relatively contained points. So, for instance, the definition of terrorism. And whereas previously there's been an implicit conflation of terrorism with Islamic terrorism, there has been a direct attempt to try to broaden that out to include Northern Irish-based terrorism or terrorism from the far right. So on that, Yes, it's probably a positive move to actually see this as violent extremism more broadly defined.
Nick, do you feel the same way? Are we moving at least some way in the right direction here?
I think the worry is that we're now moving into a debate where the internet is a cause of radicalisation and not a conduit, and talking particularly in a post-9/11 sense. And it's very interesting to hear people talking about the internet now needs to be tackled, rather than actually seeing the internet as a conduit between people who, pre-technology, could still have been radicalised. So I think the positive from this report is that it recognises that that potential audience for radicalisation is much broader than just Islamist groups.
Julian, let me bring you back in on this question of the internet then, because you know the report's broadening of the definition of terrorism seems to be welcomed by most people, but probably more controversial is the question of the internet. And hasn't Nick got a point here that you're singling out a means of communication? I mean, when the report says that people are radicalised by the internet, it's like saying they're radicalised by the Royal Mail in a previous generation. You know, it's a means of communication. It doesn't in itself require censorship to deal with the problem?
It's worth saying where we started off with this report. The prevent strategy, and it's better under this government than it was under the last one, highlights activities, what you should do to deal with radicalisation in mosques, in universities and places like that. And universities in particular required quite a lot of focus. And what we found was that none of those things were involved. And time we were told that the key issues were people meeting privately and using the internet. So that's why we started to think about the internet. And actually I think we were quite clear that what we don't want to do is to try to stifle or censor what happens on the internet. And we highlight, for example, the fact that we should be trying to get civil society groups to have material available so there are alternative views, that we have different viewpoints. Our view is very much that the best way to challenge some of the things which come online is by doing that, by using social networking, by getting messages out. So I don't think we're expressing concern over what happens on the internet in the same way as the Royal Mail at all. I think we're saying that illegal material that has been specifically ruled by a judge to be illegal should be removed. The same, in fact, as it used to be with various publications that couldn't be delivered through the Royal Mail.
Okay, so Jack, so do you see any problems here? I mean, do you think that that we're shooting the messenger rather than dealing with the problem?
Absolutely, and the phrase, the idea that this is a conduit rather than a cause, the internet is a conduit rather than a cause of terrorism is of course completely correct, and you can pick and choose your metaphors as to whether this is some sort of facilitator, but it is not driving radicalisation in some way. Again, the idea that you should be able to demand and legislate to remove material that incites violence and radicalisation within the UK might seem fair and reasonable, but as has been pointed out within the report itself and within the prevent strategy, it's such a limited tactic. You're throwing the pebble into the World Wide Web ocean, because what happens when this stuff is moved to an internet service provider outside of the United Kingdom, for example?
So do you see this as a move towards censorship, or is it simply the application of the rule of law to a new means of communication?
Well, I think one of the unfortunate things that happened with this report was that, as Julian said, talking through judicial processes, talking through fair and reasonable content that could be ruled illegal by a court, and then a court order could be issued. The problem was that somewhere between the report being issued and the media reporting on the issues involved, suddenly some new powers and some new issues have been raised which the committee didn't look into. So the committee didn't take evidence from technical experts who could talk about how to shut down websites. But somehow that became part of the media narrative because a press release mentioned it. So I think that the point that Julian makes is the most important point, is that Parliament passes the laws, whether activity is online or offline, it's for the courts to enforce those laws. And the issue that we're worried about is its moves to try and replace the courts with either a bureaucratic or quasi-judicial body who might not like the way that the courts are applying the rule of law.
So, Julian, were you aware of that kind of slippage, shall we say, between what the report said and the way the report was released in the press?
Very much so. It's always a fascinating experience working with the media, and I'm sure this channel wouldn't do anything like that ever. But seeing what is actually in the report and what is described, I mean, I don't think any member of the committee, but certainly not myself, would be keen to see all internet service providers having to decide for themselves somehow whether every single website was extreme or was not. It's simply not a possible thing to do, even if we actually wanted it to. I would like to see a system, if anything, like we have for child pornography, where there is a fairly well worked out system which relies on a fairly well worked out definition of what material is clearly illegal. I wouldn't want to see that expanded into much softer things, because frankly it's very hard to work out whether some article crosses a line about being extreme or not.
So just to be clear, in your actual report, there is no recommendation for a more punitive attitude towards internet providers, other than whether or not they're breaking the law.
No, I mean, we recommend that there's a code of conduct for them to fulfil their current rules under the Terrorism Act 2006, which does mean you have a very clear process, where a judicial process which labels material. We do not call for a much more general approach, and I don't think it would be appropriate. Okay.
So Nick, no more powers here, so presumably that sort of reassures you.
Well, the worrying thing is the fact that we have heard back-channel conversations in and around government where there are civil servants and there are officials who would like that, and who would like the ability for not to go through the courts, but to decide on their own merits that ISPs should abide by blacklists, so for certain websites to not be accessible through UK ISPs. The problem, as was described in the US around the SOPA and PIPA debate, was that the technical impact of that could actually make the internet more dangerous, both damaging basic consumer protection, but also driving underground material that you're really trying to stop. So while it's very good that the committee's report didn't take these steps, our fear is that this duty to monitor, to check everything you do online, to check you're not doing something you shouldn't be doing, is being talked about more and more in and around Westminster.
Jack, so, I mean, Nick mentioned the SOPA and PIPA, which are the pieces of legislation in the United States which are attempting to limit the freedom of use of the internet, primarily actually in the first instance, I think, for commercial reasons rather than for political censorship. But do you think there's some kind of possible overlap here in the future that we should worry about the commercial restrictions on the use of the net, because the same techniques can then be used in the future politically?
Sure, I think there's definitely the potential for slippage between things that are conducted in the name of counter-terrorism and the protection of commercial interests, for example. So you might find that there is more than an overlap. There is a worrying coming together of these separate areas of legislation. I think it's worth focusing a little bit on some of the issues the report raises beyond the internet as well. Because while saying that the internet is potentially a cause rather than a conduit of radicalisation in some way, one of the few things that Prevent has actually agreed upon, and the new Home Affairs report has agreed upon, is that grievance is something that seems to unite people who are vulnerable to a process of radicalisation. There's very little else that they've actually been able to kind of hang their hat on and say this is something that unites a demographic or whatever. Grievance seems to be the only thing. And yet there's very little there to deal with that fundamental issue of grievance in the first place. There's a focus instead on something that is a conduit. The internet is used, I'm sure, for the instances and purposes of radicalisation. But what isn't the internet used for now? You could replace the end of the sentences that deal with the internet with many other things about contemporary British life. There you go. So to my mind, having worked out one of the few things that does unite this problem, it then focuses on something that is somehow related and a part of the process, but that actually isn't at the root cause of this.
Well, Julian, let me ask you partly to respond to that communication isn't grievance, and that communication isn't cause, and that this is really what needs to be looked at.
I mean, I think that there is an interesting comment. I mean, the internet thing has got a huge amount of coverage. I've just been looking through the report. Actually, there are 2 paragraphs in the conclusions that deal with the internet, and all the rest deals with all sorts of other things. And I think the way you deal with that sense of grievance is actually dealt with in various other sections, and it's about engagement. It's about talking to people. What we found was that there were people who just felt a bit detached from what was happening in society, in Parliament and in government. And in fact, the work of the Prevent, it'll be interesting to see whether it can be saved, because it was very much presented as being a tool for government to control Muslims. which I know is not how it was supposed to be intended. But there's still a sense that it was very much in that command and control approach. And actually, to me, a lot of it is about rebuilding that trust that people have. We do talk quite a bit about how to interact with people like that to build trust in democratic institutions, for example.
Jack, isn't, when we're talking about the sense of grievance, this has been massively accelerated, if not almost entirely created by the so-called war on terror that began, we've had 10 years of now. This possibility in international relations, when you hear the talk about an attack on Iran, isn't over. Do you think that we might be, you've studied British and American foreign policy, wouldn't we be better dealing with it at the cause end here?
I think it's perfectly fair to suggest the war on terror has failed in those things that were promised to us. It was supposed to make us safer in some way. And now there is government-sponsored recognition that actually grievance is central to a process of radicalisation that may or may not lead to terrorism, i.e. the war on terror hasn't made us safer. We don't seem to have learnt the lessons of that. And you can go from the micro scale all the way back up to international relations at the macro scale, whether it's stop and search by police on the streets, whether it's media Islamophobia in general, or whether it's British foreign policy much more generally. The lessons don't seem to have been learned, and the sense of grievance hasn't been recognised in the dominant narrative that's been put forward by the government. There is a narrative targeted a section of the population, and it isn't those people that they are concerned about who might be more vulnerable to a process of radicalisation. They need to bring these people back into a narrative that they can actually rally around.
I mean, Nick, the report says that there's been a kind of diminution in the threat of Islamic terrorism, but you'd be pretty foolish not to see that related to British troops getting out of Iraq, the end game clearly in play in Afghanistan, and you'd surely also be pretty blind if you didn't think that an attack on Iran would recreate it.
Well, one of the things that the post-9/11 society has led to is a much greater acceptance for surveillance. So, looking at particularly the US, but also in Britain, we have had a fondness for surveillance, which has now gathered momentum because of the post-9/11 and 7/7 threats. And one of the strange issues we've seen is the way the private sector in the surveillance industries is actually working in those countries where, in diplomatic terms, are not allies of Britain. So there's currently a letter awaiting the Prime Minister's response from Privacy International about a UK company selling surveillance kit to Iran. And one thing we're very concerned about is that while there is a foreign policy objective, there is also a counter-objective, which is technology designed purely for surveillance and, in some cases, control of communications and mobile phones is being trialled in those countries where we would not regard them as allies or indeed role models for Britain, but then may be deployed in the UK. So looking at things like network filtering, looking at things like mobile phone monitoring devices, which have been recognised as potential tools by governments wishing to oppress their citizens, but being allowed by Western governments to be used in these societies where potentially we see some of the terror threat coming from.
Julian, let me just give you a last chance to respond on the connection here between so-called domestic Islamic extremism and foreign policy. Surely the decline in this that you highlight in the report is due to the fact that the British are out of Iraq and look like they're quitting Afghanistan.
Yes, I'm sure that's very much part of it. I think, frankly, it would be better if we hadn't gone into Iraq in the first place. I think it was a very short-sighted thing to do, both on a foreign policy and military perspective, but also on a domestic perspective. So I hope that we will cease doing things like that, which just serve to antagonise and alienate a large chunk of our population. I think what Nick says about the growth in surveillance is very true. There is a constant pressure to see more and more surveillance. And we do need to make sure that everybody involved takes their part to try to resist that constant urge.
Let me just push a little bit on the future then, because do you have a fear that if some of the talk that we're hearing out of from Ehud Barak, for instance, in Israel, from some sections of the neocons in the United States of an attack on Iran, if that were to take place, do you think that, by extension, we would be back where we started from?
I think there's no doubt that if we were to get involved in some sort of military conflict with Iran, and I very much hope that we don't, obviously, but I think there's no doubt that that would certainly serve to alienate and annoy a large number of people inside our own country, and that can't be a good thing at all in this perspective.
Okay, Jack. Final word on this. Do you feel that that some of the ways in which this politics gets discussed distorts the whole point of where the grievance comes from, because it doesn't understand the international context in which it takes place?
I think the problem with the original Prevent document and its reworked updates has been, for instance, in the first Prevent there were 4 mentions of foreign policy and 1 oblique reference to Iraq. It's just been recognised by the Home Affairs Select Committee that grievance is central. It's one of the only things that unites people who are susceptible to a process of radicalisation. If you're still not taking seriously the principal root cause of that sense of grievance, then you aren't doing justice to having a full, comprehensive counter-terrorism strategy.
Okay, well that brings us to the conclusion of part 1 of the programme. We'll be discussing the case of Abu Qatada in the second part of the programme, and I hope that you'll be back with us to take part in that. Welcome back to part 2 of the Politics and Media Show. Abu Qatada was today released on bail. The move came weeks after the European Court of Human Rights blocked his deportation to Jordan. The Home Office has said it disagreed with the decision and has maintained that the Muslim cleric continues to be a threat to national security. The European Court of Human Rights says if he were deported, then Jordan might use evidence obtained by torture in his trial. Now, before I introduce our guest today, let's take a look at some of the Home Secretary Theresa May's response to Abu Qatada being granted bail.
Despite the agreement of the House of Lords that Qatada should be deported, and despite accepting that he would not face mistreatment in Jordan, last month the European Court of Human Rights ruled against his deportation. It did so on the grounds that deportation would be in violation of Article 6 of the Convention, the right to a fair trial, because of the risk that evidence obtained from the torture of others would be used against him. Honourable members should be aware that this argument had already been considered by a British court and rejected by it. Mr. Speaker, I hardly need to tell the House that the government disagrees vehemently with Strasbourg's ruling. We believe Abu Qatada should be deported. The bail conditions are amongst the most stringent imposed for anybody facing deportation from the UK and reflect the conditions set out when Qatada was bailed in 2008. He will be under a 22-hour curfew. He will not be allowed to access the internet or any electronic communication devices. He will not be allowed to travel outside an approved boundary. Visitors will need to be approved under very strict conditions. He will be subject to a specific condition preventing attendance at mosques and leading group prayer. If any of these conditions are breached, he will be rearrested and we will seek his immediate redetention. But however strict the bail conditions, I continue to believe Qatada should remain behind bars. Mr. Speaker, it simply isn't acceptable that after guarantees from the Jordanians about his treatment, after British courts have found that he is dangerous, after his removal has been approved by the highest courts in our land, we still cannot deport dangerous foreign nationals. We continue to consider the case for a British Bill of Rights, and the Prime Minister is leading the government's attempts to reform the European Court of Human Rights. The right place for a terrorist is in a prison cell. The right place for a foreign terrorist is a foreign prison cell far away from Britain.
Well, with me to discuss this is Roger Smith, who's the Director of Justice, an organisation which was set up to promote the rule of law and to assist the fair administration of justice. And we still have Julian Huppert, the MP, on the phone with us as well. So, Roger, first of all, it's a fairly strong statement of the government's case from Theresa May.
It is a very strong statement of the case, and there's no doubt about it. This is a difficult judgment. You have, on the one hand, the perceived interests of the United Kingdom domestically. There's clearly some evidence, we don't know what it is, that Abu Qatada is a threat of some kind. And on the other hand, we have the UK's commitment to international human rights. And in cases like this, they come against each other. My view is that the UK should really be rather louder in its defence of human rights. And one of the searchlight of publicity is on this case. But you don't hear anything from the Jordanian government. And the real villain in the case is the state of Jordan, where there's a country that you cannot be safe from being tortured. And that should be brought into the picture. It's outrageous.
Julian, could I just ask you about this? Because do I have this right or wrong, that when Theresa May describes Abu Qatada as a terrorist, she could only do so under parliamentary privilege, seeing he's not been actually accused or tried or successfully prosecuted under any terrorist legislation? If she did it in the street, she'd be up for libel, no?
I'm not a lawyer. I think it would be a fascinating case, and I suspect she would probably win it. But I think what really lies under your question is this key point that he has never been charged of any offence here in this country. And I find that fascinating. I obviously haven't seen all of the paperwork behind him. If he is genuinely as dangerous as is portrayed, and as the courts have said, then I would very much like to see us prosecuting him with some offence. We have a huge range of offences, arguably far too many, and surely one of them at least would be appropriate. If he were convicted under a course of law properly with due process in this country, then I think there would be little problem with holding him in jail, and indeed he could then be sent to serve the sentence in Jordan.
Well, that's the critical point, isn't it? That he hasn't, in fact, been charged or brought before a British court, Roger.
No, well, I agree with Julian. I could have said exactly the same. I mean, Abu Hamza, for example, was convicted of an offence of incitement to murder under legislation from, I think, 1861. So you don't need any newfangled terrorism legislation. If people incite murder, that's a crime, and he's a criminal.
So why do you think the authorities haven't chosen this route then? Is it simply that they actually don't have the case?
Well, I think people like Julian, me, you, the public have no idea, because it has not been disclosed to us what he's done. Incitement is often difficult to prosecute, but clearly it can be done satisfactorily. It may be that the evidence against him is not that clear. It's clearly a complicated story. He's had contact with MI6. We don't know what that's like. And, I'm no spokesman for Abu Qatada, but one thing we know is that he's twice backed the release of people who've been kidnapped and held as hostages in Jordan. So you kind of get the sense that the story's a bit more complicated than this guy is the incarnation of evil. But he should be prosecuted. Julian's absolutely right. We're one on this. If the guy's a terrorist, he's a criminal. If he's a criminal, he should be prosecuted.
Yeah, so Julian, there's agreement obviously between the two of you about this issue. So let me ask you to speculate, and I realise I am asking you to speculate, but why do you think the authorities haven't gone down this route then?
I find it very hard to understand why not. I can only assume that they, for some reason, don't feel they have evidence that could be used in this country for an offence, which I find quite surprising. There is a slight issue that if he has committed terrorist offences in Jordan, and that's certainly the charge, then there is an argument that says that the right place for him to face that is a serious case in Jordan. And what we need to be doing is to make sure that he can face a fair trial in Jordan. Because if he has committed such offences and can be convicted there, then that's also something which I think we would want to see. People who have committed crimes and can be tried fairly for them should face the appropriate punishments where they committed them.
And the difficulty, although there's a kind of, Little Englander tone in Theresa May's comments about the European Court on Human Rights, surely nobody in their right mind can really be suggesting that anybody should be sent off to a court where people have been tortured and therefore the evidence brought against them is essentially manufactured.
I don't know which of us this is a question for, but it's a very interesting case because it changed from being a concern that he himself would be tortured, which I think had been accepted as a major concern, to where the evidence came from. And I think the comments at the beginning were absolutely correct. And what we need to do is to ask the question, why is it that Jordan gets away with torturing people to provide evidence? That should not be the sort of occurrence which is happening so commonly and so reliably that this is something we need to be concerned about. We should be taking much stronger actions internationally to stop countries at all from using torture-based evidence.
Roger, in the European judgment, there was a kind of, how should we put it, kind of get into jail free card attached to it as well, wasn't there? Because it said that if the British government could have reached some diplomatic settlement with the Jordanian government over this matter, then he could be deported.
Well, they accepted that there were two arguments, and Julian's hinting at them in the case. One was that the guy would be tortured if he was sent back, and there always was another argument that he wouldn't get a fair trial because the evidence... He's had 2 trials in Jordan in his absence. He's been found guilty on both occasions on the basis of evidence which those who gave it, once the trial was over, said they only said what they did because they'd been tortured. So it's pretty loose, the case against him. So there are always 2 limbs to his case. Now, the government got this agreement, memorandum of understanding is the term, that he wouldn't be tortured if he was sent back, and the European Court accepted that. Personally, I think there's a bit of a problem with that, but it accepted it. But he said he wouldn't get a fair trial. There was no evidence that he would get a fair trial, and he hadn't had one in the past.
There is one of the things that kind of concerns you about this, that none of this complexity, none of the, I mean, for instance, the information about the 2 previous trials in Jordan, this simply isn't entering into the media debate about this at all, is it?
No, there's a complete firestorm on this one. I mean, I've rarely seen the like of it. And it's very nice to hear an MP like Julian taking a very sensible view on it, very balanced view, because he's in a bit of a minority, to be honest. And there's been this firestorm. Abu Qatada has operates as a projection of everybody's evilest thoughts. He is the most evil man in the world, which is unlikely to be true. And all the background detail has gone. And actually, you should really have, sitting next to me, it should be the ambassador for the state of Jordan, who can defend to you and to me and to Julian and to the world why the standards in his courts and in his police stations are such that, historically, everybody admits that there's a problem about torture. The Foreign Office, we go back to 2001, 2003, Foreign Office said that this guy couldn't be deported to Jordan because of torture. Jordan was is the alleged site of one of the CIA's torture prisons in the rendition program. You know, Jordan has some pretty heavy human rights questions to answer. And, you know, thank heavens for this channel is a place where that issue can be raised, because there's very little space in the British domestic media to get that out.
Julian, just let me ask you about that same issue, about what Roger calls the firestorm in the press, because, I mean, you know, if you were to read some of the papers today, you'd think that the most pressing question in this case, and possibly the most pressing question in the nation, was whether or not Abu Qatada can go on the school run. I mean, it's simply not dealing with serious issues seriously, is it?
Well, absolutely. I mean, Roger's right to say this has just become such a massive media circus, and it's a great shame that people aren't getting involved. It has all the elements for a good British tabloid story with a foreigner who looks a bit funny and all the rest of it. But yes, you know, the real question isn't can he go on the school run. I think 22 hours detention is already quite long for somebody who isn't being convicted of anything in this country. And it is a great shame that we're not having focus on what the real questions are, which is about what happens in Jordan. And it's not about whether we have, like the European Convention of Human Rights, but it's being used by a number of people with vested interests as an example of human rights law, which I think is rather unfair, because they're not looking at the facts in this particular case, or indeed the fact that we can just simply prosecute him if we so choose to.
Roger, when you look back over the kind of history of Abu Qatada's imprisonment and detention, it's a considerable length of time, in one way or another, that he's been detained. Aren't we, in effect, in this case, have abolished habeas corpus, the necessity to bring a body before trial?
Well, you could say that to some extent. I mean, it's interesting to compare the treatment of people like him and treatment in the Second World War of suspected enemy aliens, because they were just interned throughout the war. And there was a legal challenge to it which got nowhere. I think what you can say is that the commitment to human rights now has actually made a difference, and there's at least been a battle about it, and at least in the end he's got out. I think it's a complicated story, and it's not one that it's quite difficult, because under basic law, he's a foreigner. We have reasons to think he's a threat to national security. He can be deported. That's the basic position. I think everybody, you begin with that. It's this international obligation not to be complicit in torture, which we've absorbed into our culture and into our international agreements since the Second World War, that puts a brake on that. and we're really having to grapple with that.
Julian, do you feel that the furore around this case is part of a wider attempt to erode civil liberties and to create special categories of people to whom the normal process of justice doesn't apply?
I fear very much that it is, and that I've heard chilling comments from a number of MPs about this and a number of people in the media. I mean, I think it was Hazel Blears on the Today programme, the former Labour minister responsible for introducing a lot of this legislation, who was saying that she felt that, maybe you would have to just keep people for many, many years, perhaps indefinitely, which is just something we shouldn't be allowing. I mean, it starts to feel uncomfortably like the sort of stories you had in the Soviet Union. And that's just not how we need to go. There are definitely people who would like to pick a fight over the Human Rights Act and the European Convention on Human Rights. I often think because they don't fully understand what it actually is. And so they try to generate particular cases like this to try to wedge open what is a commitment we do have in this country to really understanding human rights and caring about it. And I think there is an agenda to try to reduce the protection. And the protection will first stop for people who are foreign or who look a bit different or whatever it might be, but will then continue to cover everybody.
Julian, just on the question that Theresa May raised in that clip about the introduction of a Bill of Rights in this country, 2 points. Do you think the government will get around to it? And if the government does get around to it, do you think it will be more or less liberal than the protection now provided by the European courts?
I think there's a big question as to what such a Bill of Rights might actually be. If we have something which is additional to, provides more rights than we already have in the European Convention, or indeed if we signed up to some of the international instruments that we're not currently party to, I think that would be a good thing. What won't happen, certainly won't happen as long as there are Liberal Democrats in the government, is to replace the Human Rights Act and hence our participation in the European Convention on Human Rights with a Bill of Rights that waters down what we have. I just don't think that is something which we would consider acceptable under any circumstances. And I find it fascinating, some of the people who argue against the convention, because it was actually Churchill's great legacy that the European Convention was largely drafted by British conservative lawyers who were essentially saying, we in Britain have the right standards of human rights, we want the rest of Europe to follow them. It would be a great embarrassment if we then said, actually, we're not quite up for them anymore.
Roger, what do you think about this? Do you think that the government is moving towards this, and what do you think the character of it would be?
Well, I think there is clearly a campaign against the European Convention on Human Rights and the Council of Europe. I think sometimes that's muddled with the European Union. But one has to remember in relation to that the conduct of Jordan is contrary to, well, it breaches Article 3 if it was in Europe of the European Convention, but it's also against the UN Convention against torture. So these are international norms, not just European, international. The discussion of the Bill of Rights seems to me completely absurd and bizarre, because in the clip that Theresa May is arguing for a Bill of Rights so that she can send somebody away from the country. It's really a Bill of no rights she wants. She thinks there are too many rights. Now, anybody who uses the term Bill of Rights in this country is referring to 1689 and one of the great movements forward of British liberty. And it's bizarre to have taken that language and to say, well, actually, we want another Bill of Rights because we want to take away liberties. That's just playing fast and loose with language. We are stitched into the European Convention on Human Rights. Our whole structure in Europe and the world fits together in relation to that, and it's just completely wrong to argue that we should be out of it.
Julian, I mean, you say that, you know, so long as there are Liberal Democrats in the government, no more restrictive Bill of Rights will be passed. But I think, you know, Roger's got a point there, hasn't he? That's what's in Theresa May's mind. So does this mean essentially that that the Bill of Rights is dead for the purposes of the coalition government?
I find it very hard to see how anything new which came out and restricted rights could happen. I think there are certainly things where one could expand it. One could look at greater rights for children, for example. But I certainly wouldn't be prepared to see something which restricted the protections that we already have for human rights. And I simply don't think it will actually happen. I think it's a nice piece of rhetoric, and I think it will be used in the media quite extensively. But I don't think that is something which will actually deliver on this Parliament.
So, I mean, essentially what you're saying is that Theresa May is playing to the Tory backbenches and the Shires here, and that there isn't really a prospect of fundamental change in the law.
Absolutely. We've seen her do it before with her conference speech where she talks about a fictitious case of somebody who couldn't be deported because they had a cat, which was simply not the case. So we've seen her use this sort of rhetoric before to play to her own crowd. And I can absolutely understand why she wants to make it very clear that she is not pleased that Abu Qatada has to stay in this country. It's clear that she would like him to be deported to Jordan. And I think, frankly, if we could have the right sort of assurances and be certain that there was a fair trial, that would be the right thing to happen. I don't think any of us are massive supporters of his. So she is looking for some rhetoric to set against that.
Roger, if there were to be a sensible Bill of Rights in this country, if it were something that were actually going to advance the condition of civil liberties, what would you expect it to be dealing with, given the current kind of...
Well, if you ask the Tories who argue for one, well, what rights are you thinking of? You used to get, before the election, jury trial and legal aid. Well, both of those are a little bit under threat as a result of cuts. So it's a little difficult to see quite what rights people are thinking of. And frankly, I just think we're having enough difficulty with the Human Rights Act, which I think is a really good piece of legislation, the European Convention, in a sense. Let's have another decade or two with that before we move on. Julian's right. You could think about children's rights. You could think, for example, about the regulation of the press. Actually, the way that the European Convention deals with the balance of freedom of expression and privacy could probably be more modernly expressed. You can think here and there of little amendments that it could make. But frankly, the European Convention is broadly what we need. It's, as Julian says, it's broadly our common law values put into a code. And we're having enough difficulty absorbing that. Let's just sort of stay with that for the moment.
Well, Roger Smith from Justice and Julian Huppert, who's been with us all the way through the programme. Thank you both. Thank you for watching, and I hope you'll join us on the Politics and Media Show next week.